All right. Good afternoon, everybody. We are so happy to have you back with us today for another wonderful Connectionology webinar. And I couldn't be more happy and excited just because we've got Lloyd, who's one of my dear friends. I've not seen him in so long, but he has been out there working trial after trial in Atlanta, Georgia. He is back with us today to talk about a very important topic and to talk about one of his most recent verdicts. And then we've got Cody coming in from Fox AE. He is going to show you some very cool things as well. So stay tuned for his part of the presentation. And then, of course, my favorite, John Romano, who's here to help moderate the webinar. Um,
Uh-oh.
and I mean
Uh-oh.
that. So we're excited to have you with us, John. We're going to have a good time today. You guys, I hope you ask questions. You can put those in the Q&A box or the chat box, and Cody will keep an eye on them. And then later on, we're going to take a quick break so you can meet some of my wonderful partners that we work with over at On Point Legal Nurse Consulting, Fox AE, Strategic, as well as HMR. So get ready, have a great webinar, and I'm going to hand this over to John Romano. And if you guys need anything, please let me know.
Thanks,
John,
Ginger.
it's all yours.
Ginger, thank you very much. And again, thank you, Ginger. You are magnificent in what you do in our world of CLE. We were chatting just before we came on the air here for the webinar. We are at over 500 webinars that Ginger has done with Connectionology since COVID. And they have been on a variety of topics with speakers from all over the country. And Ginger is doing all of these things day and night, holidays, weekends, when the rest of us are off doing other things. And Ginger, your devotion and dedication to the legal profession, what you're doing in CLE is just beyond extraordinary. And you do it with such a magnificent attitude that is uplifting to everybody. So thank you over and over again, Ginger. Thank you. I am really thrilled today because we have two folks that are not only two of my favorite folks on planet Earth and what we are all engaging in our practices and in the handling of these cases, not only skilled people, talented people, but just enjoyable people to be around and people who go out of their way, each one of them to do everything each one of them can to help everybody else. So let me introduce, first of all, Lloyd Bell from Georgia. We're about to hear from one of this country's greatest courtroom lawyers, and Lloyd Bell. At a very young age, selected to be a member of the Inner Circle of Advocates, which is the top 100 plaintiff trial lawyers on planet Earth. I do think actually there are some criminal defense lawyers who have been in the inner circle also, but every lawyer I know in the inner circle is not just a good lawyer or a great lawyer, but they are way up here. So that speaks so highly of them. Another thing a lot of people don't know, way back in the beginning of his career after he finished his schooling, Lloyd was an officer in the United States Army and went through the rigorous Army training that any officer in the Army has to go through, and then morphed into becoming a JAG officer, where he was doing all kinds of work on all kinds of cases and obtained just that wonderful experience. Over the years, he's been a leader in the bar, a mentor, a speaker all over the country, and a great teacher who knows how to get what is in his brain into the brain of those who are in attendance at these meetings. But when it comes to the courtroom, and many of you have heard me talk about this, in personal injury and wrongful death cases, in terms of the most challenging and difficult cases day in and day out, there is nothing, in my view, more difficult than a medical malpractice case. Everything about it, more expensive, more time consuming, more emotional, more intense personalities, and great meaning and effect on what happens in the future regarding care and treatment. And the great lawyers consistently handle and get great verdicts in these medical malpractice cases. They are far more difficult than so many of the other types of cases. Listen to just a few of these verdicts, though. 2022, a $75 million verdict, the largest medical malpractice verdict in the history of Georgia. A $26 million verdict in a medical malpractice case in 2017. $18 million verdict for the family of a veteran in another one. And then a $15 million verdict against the largest healthcare provider in Georgia. And I could go through a list that goes on and on and on. He also stays with the client forever. He has had some cases that he's tried not twice, not three times, but going in for a fourth time. That's the kind of a lawyer that he is. And we are just privileged and such an honor to have Lloyd Bell with us today, but somebody that is going to teach us things that we just haven't even thought about. His wingman, so to speak, for today is a guy that is a great, I don't know what to say, but teammate, leader in his own right, teacher, author, speaker, Cody Roberts, founder with his wife, Vicki, of Fox AE, and they do medical illustrations, animations on both liability and medical issues and liability. But Cody is a visionary when it comes to demonstrative aids. He will get an idea in his mind and say, why don't we do it this way? It'll have far more of an impact on the jury. And I go, I didn't even think of that, Cody. He'll come up with that. He's an engineer who recently provided me with a tour of the University of Missouri, where he obtained his engineering degree. Thank you, Cody. Thank you to your mom and dad for taking us on that tour.
We had so much fun.
And we love working with Cody and his team. They are magnificent. So I'm going to turn this over to Lloyd Bell and to Cody Roberts. Guys, take it away. We are in for a fun ride this afternoon. The floor is yours.
Well, thank you for that introduction, John. Nobody gives a better introduction or a nicer or generous introduction, and I really do appreciate your nice words. You've been such a teacher of mine for many years, as we were talking about before we went live, and it taught me so much about the importance of medical literature, reading the type of things that the doctors are reading, and you've been a big positive influence on my practice. So thank you for that. Really excited to be here. I appreciate the invitation. It's great to see Ginger again, although it makes me a little bit sad that we lost her. She worked here in Georgia with our trial group, our trial association, for a number of years, and everybody was sorry to see her go. But I'm excited to be here and talk about a verdict that we got this past July, medical malpractice case. But there are a lot of lessons, I think, that would apply to really any kind of practice. I'm going to bring this out in a little bit more detail, but Cody was a big part of our recent success. I turned to Cody to help prepare a medical animation illustration on something very difficult to illustrate, and I wasn't particularly optimistic we would capture it as well as we did, but we did, and it turned out to be incredibly useful. So the last thing I will say is, if you like to try cases, medical malpractice is the place to go, because you will not find more motivated defendants to defend their cases and more motivated lawyers defending them. They give you plenty of opportunities for trials. I've got one coming up in December. John was referencing it. It is the fourth time we've tried the case, but it's the first time we've tried the case with the judge that had been there from the beginning, and with the right circumstances. So I'm excited about that. But the case I'm going to talk about today is the case of Glenda Yarborough versus Cardiovascular Group of Georgia and some other related defendants. And the theme in the sort of the scope of the discussion today is about technology and using technology in the courtroom. This has been a topic that I've enjoyed talking about for years because I think it gives us such an advantage if we embrace the technology available to us, learn it, learn how to use it effectively in a courtroom, and it just puts us so far ahead of what the defense can do. And I'm always kind of on my soapbox, preaching to lawyers to cast off all the excuses and jump into it and spend the time to learn it. So what I'm going to do today is I've got a presentation. I'm going to show sort of what the issues are that we're trying to address with technology. I'm going to talk about some of the tech that I use in preparation for trial. And then I'm going to show you the slides that I used in opening statement that incorporated what we developed pre-trial. And of course, this is probably not news to anybody on this webinar, but the success of trial begins with the hard work pre-trial. The depositions, the discovery, the working with consultants, the focus groups, all those things that go into it. So I'm going to share my screen here, and hopefully everybody can see that.
Yes.
All right. So the title is sort of high tech and low tech. I talk a lot about technology, and people's minds tend to go towards things like animation or fancy computer call outs, and that's certainly a part of it, and I'll talk about that. There's also a role for low tech as well. But to start off with, we sort of have to define kind of what the problem is. What are we trying to accomplish with technology, both low tech and high tech? What's the issue? And the issue is always about communication. That's what we are. Sometimes people talk to us about how we're storytellers, but we are trying to get information from our brains into the jury, or some cases the judge. But there's resistance, and we all know this when juries come in. We see them kind of come into the courtroom, and there's an air of sort of resistance. Why am I here? I don't want to be here. I've got things to do. And there's apathy. They just don't, they start off and it's, don't really care about what somebody else's problems. I've got problems of my own. The jurors can get bored. I mean, the process until the trial kicks off, I would say, is very boring. They have to sit around, at least here in Georgia, they sit around in big rooms waiting to be herded down to the courthouse or to the courtroom. They wait in lines. They're constantly being told to wait, wait, wait. And the whole process it can be very boring. Confusion is a major thing that we are aware of. You're getting jurors from all walks of life, of course, some who have very high education, some who working people who didn't go very far in their school at all. So we're conscious of confusion, and particularly in medical malpractice cases, where just the thought of some of these issues involving cancer or heart issues is just by its nature can be confusing. Of course, we want to create an environment where information is sticky and memorable, but people tend to forget things. So when we're putting together our visual strategy on how to present information, we're constantly thinking in terms of how can we make things sticky? How can we make things memorable? So we use a lot of devices like loops and repetition and supporting demonstrative exhibits, which I'll talk more about in a little bit. So our job is to cut through all that, cut through those areas of resistance and bring the boring to the interesting. Now, I like these slides. I borrowed some of these from my friend Moses Kim, and he talks about, bring it from here to here. Let's carry it from boring to interesting, from confusing to simple. Let's break things down. And in the process of doing these activities, in pretrial aspect, it makes us know our case better. So that all this preparation to try and make it more understandable to a jury also makes it, not coincidentally, makes it more understandable to ourselves. And then, of course, forgetful to memorable. We want to make things exciting. We want to make things memorable. I like this slide a lot because it reinforces that at a certain level, We are entertaining the jurors. Now, trial lawyers don't typically talk like that. It doesn't sound very serious, and we're entertainers. But in a sense, we are. This is theater. Trial is theater. We have a story. We've got conflict. We've got props. We've got costume. We've got story arc. All those things we'll talk about in a little bit. But we have to be conscious that maybe we're not Kendrick Lamar at the halftime show, but if we can make it entertaining, then that's more likely to be memorable and more likely to put us in a position for success. And then we want to move it just from memorable to impactful. We want to motivate jurors to take strong action. You may have heard at other seminars that there are things called high activation emotions and low activation emotions. And the high activation emotions, those emotions that we want the jury to feel, that's going to translate into action, into a desire to affect change. We don't want to live in a world of low activation emotions where jurors will be full of sorrow and sadness and despondency, where they won't feel motivated to take strong action. So we have to incorporate those elements into our case. So what are our technology tools to sort of help address some of these challenges? I'm going to talk about the apps that I have been using, for some of them for over a decade, maybe 15 years, and that are sort of my go-to, both in pretrial and some of these actually in trial. TrialPad, I'll talk about that and give a little demonstration. By way of introduction, TrialPad is a way to present evidence in a courtroom yourself. So you don't have to hire a technology support person to put your exhibits up, your animations, your video clips. This is a tool and a program to do it yourself. And that's probably one of my absolute top apps. TranscriptPad comes from the same suite of applications from I think it's called Lit Group is the name of the company. TranscriptPad is a way to read depositions, annotate depositions, and create very good reports to allow you to make effective cross-examinations and direct examinations. ChatGPT, that needs no introduction. I was putting the final touches on my presentation before we got going, and it occurred to me that some of my slides are even a little bit out of date because AI is moving so quickly, and there's so many great products out there, and I'll talk about a few of those and how I've incorporated AI. And then Keynote, which is the program that I'm presenting with today, the Apple equivalent to PowerPoint. That is a wonderful program to create a slide deck to use for opening statement and closing argument. It's also a fantastic program for creating slides to blow up on boards. Some of y'all on this webinar may favor the physical boards. I have some good friends who really like to have a bunch of boards and they're forever using boards in trial. Others who don't like boards at all, they all want to be digital. I would advocate for a mixed approach, and I'll talk about that. But Keynote's a great product for that. And then the Anatomy app that I use, which I'll demonstrate here in a minute, is one of my favorites as well. I'm going to start with the Anatomy app. And this is a program. It's called C Anatomy, C.Anatomy. And it sits on the website, or excuse me, sits on your desktop. But it could be on your iPad, laptop. And what it is it's just like it says, it's an anatomy app, and it gives you all the different body systems that you may want to show. Obviously, you see the skeleton here, but the level of detail and glazing and just the artistry of it is really compelling and fun to look at. But you can add the different body parts. You can put in the arterial system, for example. It starts off at kind of at the gross level, and meaning the major structures, and then you can get more minute. But what's great about this app is when you click on the different structures, you can see it pops up a description on the left, and you can learn about that structure. What parts of the body it supplies if it's part of the vasculature. Um, Here you can get into more detail of the nervous system. You can add connective tissue. You want to have, demonstrate the cartilage, whatever it is you're trying to demonstrate. It's just very helpful. And then you can pull systems out to really zone in on the part of the body that you're interested in and what you're trying to show. And then you can take a screenshot. And then all of a sudden you've got a medical illustration that you can drop into Keynote, PowerPoint, whatever. Um, and uh, and it's just very useful. Um, you can also isolate just the specific organ system, that you want to talk about. Obviously, I'm isolating the gastro system here, the digestive system, and you can just see the quality of the artwork is just really nice. I'm going to move along here a little bit. This is really cool. I know a lot of folks, obviously have back injury cases, herniated disc, that kind of thing. What's cool is you can isolate one of the spine segments, and then you can manipulate it, and you can, really, really use it. Now it's got a whole library of different information. It's got an atlas of where they have sort of pulled out a body part and put the labels to it, so you can learn about the different parts of the anatomy. It's also got a section on radiology, which is really interesting. And I don't have that on the slide here, but you can see at the top there's a section where you can look at radiographs. And anyway, the point is you've got all of these resources. In this program, it's just ridiculous. I think it's like $200. Maybe it's a subscription model now, but a couple $100 a year, and you've got just this vast resource. I use this anatomy app all kinds of different ways. I mentioned taking screenshots that I can use as an exhibit. That's a simple way. I'll take it on my iPad, and I'll take it to a deposition and then pull it up live. And then, with the defense expert or my expert, isolate the part of the anatomy that we're talking about and discuss it, whatever points you're trying to make. I've had defense medical experts during the deposition on the record who were so impressed with the product start asking me questions. Well, what's this product? This would be really helpful for me to teach my patients. And the defense lawyer quickly objects and tries to move on. But anyway, that's a really nice app. It's called Complete Anatomy, or C.Anatomy. Understand Ginger's recording all this. I'm happy, of course, to share my slide deck as well. So if you don't write one of these down, you'll have an opportunity. So this is another program I use, which is TrialPad, I mentioned earlier. And if you think about TrialPad, it's basically a exhibit presentation program, and it's gotten better and better over the years, more useful. But as you can see, you can organize with folders however your brain works, and everybody has different ways of organizing. For a trial, I always have the pre-trial order first at the top. I'll have a bucket for my exhibits. I tend to show things that are useful or things that are on my side. I show in either green or blue. If it's on the defense side, I show them in red just to kind of quickly distinguish. But in this folder, you drop all of your exhibits, and this program can handle thousands of pages of medical records. It can handle audio and video. But you click on your exhibit, you can pull it up. You can use this on the iPad wirelessly in front of a jury. It gives you all these tools to highlight. You can highlight information. You can call it out, which is really helpful so the jury can see it, real big up on the screen.
Oh, that's nice.
It's got great features. It's got this nice John Madden feature where you can circle things and, plot out plays. We could use John Madden here in Atlanta. We've been suffering with our Falcons lately, but anyway, and this is a really nice feature too. It's got the ability to redact. Now, why would you need that? Well, because no matter how wonderful your paralegals, and I've got a great paralegal who's probably the best in the business. Um, some collateral source might sneak in on a document. You might not see it until all your exhibits have been loaded. So it gives you this nice feature where you can redact information that needs to come out, like insurance or whatever. It's got this other feature too, where you have a place where you can put your own personal notes. And this is not projected. These are like your teaching notes that are just visible to you. But it can be nice to put a couple of notes on each exhibit just so you don't forget the point that you want to, that you're interested in making. I mentioned that it can put you can drop video clips into it, and then you just press play, and then the video will come out, which is very helpful. This is really good for cross-examination. Although I would caution folks not to overdo it on the 60-minute style video clip impeachment. If you do too many, it can look a little bit bullying, and you really shouldn't play a clip unless it is important to play it. I mean, unless there's a real distinction between what the witness is saying on the stand versus what they said in deposition. But if there's a big disparity, they really are off in a different world. A video clip can be very compelling, and much more than just reading a deposition. What didn't you say? And this is what you said here, and now you said it here. You just play it. It can be very, very helpful. Now, the real power of this app is it gives you a place to organize all of your examinations. So you're going into trial. You can see, let me back up a little bit. I organize them by witness. So I'll have the witnesses I'm going to call. I'll have them organized in the order I'm going to call them. In Georgia, we can call defendants for cross-examination in our case, and generally the defense lawyers are not allowed to do a direct examination in our case. They have to wait until their case is being presented. So it can be very powerful to start off a case with defendants on cross, establish your case, build out the structure of it. And this app lets you, put in, develop folders and then put the exhibits in for that particular witness. I organize my cross by chapters. I'll have a timeline that'll have the medical records in that timeline. And then, you can pull up the records very quickly. You can have them pre-highlighted if you want, or you can highlight them on the go, whatever you're comfortable with. But this process of organizing, of you doing the organizing before trial has a couple of benefits. First of all, it fuses this information into your brain. If you outsource it to somebody and say, you put together my keynote presentation, or you organize all my exhibits for me, here they are, you do all that work. People can do that. I mean, there's a lot of companies that'll provide that kind of support, but you're not going to have the benefit of living with those documents and just making the decisions on where to organize them, what's important in this document. And so TrialPad kind of has that benefit too. Yeah, a lot of times I'll be in an airport with my iPad, and I'll just open up TrialPad and just start looking at exhibits that, for an upcoming trial. And I almost always see something new every time I do that. So it's just a great program.
Yeah, and Lloyd, before we move on, we had a question about recording the C anatomy. By the way, what a cool program.
Yeah.
Does that help you kind of learn about the case as well? And also, how do you record that imagery and utilize it, like you were saying?
Yeah, well, there are a couple ways to do it. You can just do a screen capture. There are programs on Mac that let you do that. I think it's a Command Shift and then number 4.
5.
I think 5 is the whole screen, and 4 lets you kind of define your screen. So you
got it.
you just do screen grabs. And there's a feature I've been in a Mac environment forever, but I know there's corollaries in PC world for all this. You can do a screen recording. So when you've got the application open and you're poking around, You just record your screen, and then you can edit it and take clips of what you need. So it really just depends on what you need, but very easy. I mean, this is, I mean, it doesn't take much to, I mean, there are YouTube videos on everything too. So if you have a question, and Chat GPT will answer so many questions. Um, so that's that. So the next one I'm going to talk about, and this is part of that, like I mentioned, that TrialPad suite with Lit software. And this is Transcript Pad. And this is another favorite, which I really enjoy, but it looks the same. You set it up by case, you drop in all your depositions. It's really easy to import the depots. They need to be in an ASCII format, which is very basic. Your court reporter probably provides that anyway. And you pull the ASCII file into it, and it just grabs it, and now you've got a deposition. You can sync the video with it, which is really helpful, because when you make a clip, you can export it into a video clip as well. So the way this works is you can see down on the left, these are all kind of issues that I have defined. For whatever reason I wanted a category called differential diagnosis or follow-up, things that I need to follow up, whatever it is. And then to create a clip, you literally, if you're using your iPad, you just click your finger on the start line, in this case, line number 23, and then you click where you end. And then that'll pop up and you assign a code. You can do a bunch of things. You can assign a code to it, or you can copy it if you want to copy and paste it into a document, or you can email it to somebody. Sometimes I'll see a good clip or something from a depo, and I'm proud of myself that I asked a good question and got a good answer, and I'll send it to co-counsel to show how smart I am or clever. And but it's nice to be able to share information that way. And then you can assign multiple different codes. You can see all your codes will appear. You can put whatever color you want to on it. So what's the benefit of all these codes? Well, the benefit is once you have gone through the deposition and read it and highlighted or put the codes that you want, then you can create, I'll move to this, you can create reports based just on those codes. So in this case, I want to create a report on coagulopathy issues. I click that box, and now it'll create a report either in the single deposition that I'm interested in or across all depositions, because those categories are being used, those issue codes are being used across all depositions. So I can create one report where it captures everything that's been said about coagulopathy. It's a PDF, so it's easy to email it. Pops up in your PDF viewer. It's very clean, page numbers, defines what the code is. Just very, very helpful. You can save the report till later. And then when I do a cross-examination, I'll print the report out by issue code. So I'll have the report, exactly. Now the old way to do it, and that I used to do, was to have the deposition transcript, with these things, little sticky notes, and I would have the sticky notes lining the side, and I was forever dropping sticky notes and trying to move back and forth. And you can do it that way, but it's just not clean, and it's prone to error. I mentioned you can export video clips. Once you prepare your video clips, you can save them on your file directory. You can create this is one of the best features too. I was going to say you can create a directory of your video clips so you can see exactly what they are. You can label them any way you want. So if you have a video clip where a doctor says, agrees that a hematoma is a life-threatening condition, you can label the clip that, Dr. Smith, hematoma, life-threatening condition. So all those little shortcuts, little cues, to make you more efficient and to reduce the friction at trial is very helpful. And one of the most powerful aspects of this program is that you can do word searches across all the transcripts. Now, in this case, you can see I've got a ton of deposition transcripts, but you can search for a word like hourly, and because I want to see how much people charge per hour, and have that captured, and then it'll show you all the different places where the word hourly appears, um, and then you can annotate your search result and say, search for the word hourly, and then create a category called hourly, and that'll capture every expert who's talked about their hourly rate. So that word searching feature is very valuable. You can highlight, you can do all kinds of different things, but those are sort of the more.
So Lloyd, what you're telling us is that simplifying information and making it easy to understand and interpret isn't just for jurors. It can be used for attorneys as well. As you're dissecting all this complicated stuff, you can easily refer as things are organized. Man, I love
Well,
that.
exactly, but it's all connected. You can't teach something unless you know it at a very, you can't teach it effectively unless you know something at a very deep level. And so you have to put the work in to learn these things. I mean, to learn your record, to learn your medical records, or whatever it is you want to teach. Um, and then, because that's what we are. I mean, that metaphor is used a lot, or analogy is used a lot in trial, that we're teachers. Sometimes we're teachers, we're mentors. That's another one you hear a lot. But there's truth to it. I mean, the jury's looking to us. Remember, going back to what our main job is, which is communicating and getting information from our brains into the jury's brain. Um, to do that, we have to really have confidence in knowledge and really have this information baked into us. So that it's just, you've got the timeline in your head. And then when the defense says something that's wrong or inaccurate, or their expert does, it just hits you immediately because you've worked on it for so long, and you've used these tools to really understand the evidence. So that's a big one. Now, another thing that's very helpful with Transcript Pad is you can copy the entire transcript very quickly and then drop it into some of these AI engines. And I'll talk more about that in a minute. But and now we're using AI for more deposition summaries. We're using AI for all kinds of different uses, as I'm sure a lot of folks who are watching this are
Hey,
as well.
Lloyd, real quick before we jump into that next
Yeah.
segment, I got Ginger ringing me here, and I think are we bringing in Ginger? Would now be a good time to bring in the two sponsors?
Yeah, this would be a great time. And I'm very excited because we are bringing in Blue from HMR and then our dear friend Patrick, who works with On Point Legal Nurse Consulting. And for those of you who are new to the webinars, you get a chance to not only meet them, but hear about some of the great things that they do. And they're just some wonderful partners of ours that we've been working with for many years now. I can't imagine doing what I do without them. Um, and I'm going to bring in Blue first with HMR, who's going to tell you about some of the great things that they do. He's coming out of Scottsdale, Arizona, and but I know that HMR does, work with clients and attorneys all around the country. So let me bring him in real quickly. And then, of course, I've got Patrick coming in as well. Blue, it is great to see you. I know I'm going to see you next week in Texas at our Depositions or Trial seminar. I know a lot of people have been trying to get into the seminar. It's been sold out. All I could say is we'll let you know when the date is for next year. But if you are interested in coming to our TBI seminar, that is going to be in Sun Valley, Idaho. It is our fifth annual seminar. John just sent me a draft of the agenda, and my jaw is dropping because I love it. This one's probably going to sell it as well, so you might as well get ahead of the game early and go to our website, connectionology.com, to check it out. But HMR's been with us many years now. They come to all of our seminars, and we're very grateful for what they do. But Blue, we're excited to have you with us.
Thanks, Ginger. It's always a pleasure. Cody, it's great to see you, my friend. John, good to see you as well. I see you popping
Yes,
in.
sir.
Lloyd, excellent presentation. A lot of great nuggets of information here, man, as usual.
Thanks,
It's
Blue.
great to see
Appreciate
you
it.
as well.
Thanks, man. Appreciate it.
Absolutely. So who is HMR? HMR is the premier funding source for personal injury and plaintiff law firms nationwide. There's three types of funding that I just want to touch on here briefly with everyone. First of which is going to be the medical funding piece. For medical funding, I always like to tell everyone that we do function in 39 states currently for the medical piece. And I like to tell everybody that just to let you know that we do work with providers nationwide, facilities. We are fortunate enough to work with some of the best traumatic brain injury facilities in the nation as well. So if you have some TBI cases and you want to bounce that off me, obviously reach out. Second type of funding is going to be the case cost funding piece. So experts, right? Video recreation specialists like Cody and his team. Whatever you need to bring in to shore up your case and get it done, especially on the litigation side, that can become sort of a heavy lift. We do this on a case by case basis. So it is a single case event. You can pick and choose and be like, hey, Blue, I'd like you to fund it. This is going to be a big one, right? Or whatever it is. But it is all non-recourse. All the funding that we do is non-recourse, and that is due to the fact that we do really vet the cases up front. I know John Romano knows that we do a great job on that as well. We do our diligence up front just to make sure that that it is going to be solid. The last but not least is going to be the pre-settlement funding piece directly to the client. We all know this is could be possibly the toughest time that they've had in their life, right? Life goes on. They need to, mortgage payment, vehicle, whatever it may be. If that is a need, also becomes a heavy lift, please reach out. As usual, I will leave my contact in the message board. And yeah, like Ginger said, look forward to seeing everybody out in Texas, and it's going to be a wonderful time.
Blue, thank you for all you and HMR, the things you do for us at Connectionology. It has been a wonderful partnership working with you all. But I want everybody to just know this. When people say to me, well, why in the world do you use a given company or a firm or an expert? With HMR, it's easy. We trust HMR. We trust you to look out for our client, to look out for the important things in the case, to vet the case, vet the client, help us make the right business decision, because experience has shown us if we make the right business decision, we end up getting better results for our clients. And you all are responsive. Everything makes sense when it comes to working with HMR. We love working with you and can't thank you enough. Great job.
Thank you, John. I appreciate the kind words.
Absolutely. And Blue, don't forget to put your information in the chat box, okay? All right. And then as you guys can see, our other friend, Patrick, is coming in from On Point Legal Nurse Consulting, another fantastic company. Usually Patrick is traveling all around the country. He is testifying. He's going to everybody's trials. He's been a nurse for over 20 years, and he is probably one of my favorite people. So I'm so excited that you're with us today, Patrick. The things that you do, the stories that I've heard, I mean, you make such a huge difference in people's lives. And I'm so proud to know you. I'm glad that you're here to share all the good things that OnPoint does for all of our attorneys.
Well, thank you, Ginger. Nice to see you again. John, of course, Cody, wonderful to see you. Lloyd, nice to meet you. I'll actually be in Atlanta on Thursday. So
good.
For the Elder Abuse Seminar. So
I'm speaking at that, Patrick. I look forward to seeing you there.
Yeah, I'll see you there.
So
thank you again for having me. Wonderful presentation. And I always learn something from Connectionology. So thank you again. Like Ginger said, my name is Patrick. I'm one of the directors over at On Point Legal Nurse Consulting and Expert Witness. We're a full service litigation support company. So we provide experts for both nursing experts like myself, medical experts, and then a lot of behind the scenes stuff. So we can do your record retrieval, record organization, we can do merit screens, and then kind of go through the whole entire litigation process with you guys. We really like to consider ourselves an extension of your staff, so we can help with those sometimes complex questions or just the simple questions that you don't go down the Google medical rabbit hole. On Point is run by 3 nurses, myself, Dawn, and Ingrid. Ingrid's been a nurse for over 40 years. Dawn's been a nurse for about 35 years. So I am the junior at 21 years. Some of our special reports that we do, we have 3 life care planners on staff that can do your life care plans. The pain and suffering report that John always talks about, which is the non-economic damage report. It's a comprehensive report done by our nurses in-house. Really shows a different perspective to the claim or the injuries that happen. We really try and interview the client if we can and the family, really to get an idea of how their injury has affected their day-to-day life. We also have a new program that we just launched a couple months ago for record organization. We can get your records organized within 24 hours. It really bookmarks everything, hyperlinks everything, going to what Lloyd is talking about, making that process a lot faster and making it easier to read, easier to teach, and of course, easier to present. So we can do that for you guys within 24 hours. We do some AI stuff, mostly to capture a lot of our duplicate records because we get these enormous volumes of records. And so we try and filter out those duplicates to give us one good medical record to review. So I'll put my information in the chat box below. Like I said, I've been a nurse I love being a nurse. I love the legal side as well. We're here to help. We're here to answer questions and really support you guys in anything that you might need. So reach out if you need anything. And as always, Connectionology, it's a wonderful group. I've worked with Cody before. I've worked with Blue before. It's a really wonderful support group. So we're happy to help in any way we can.
I have told everybody, and you know this, Patrick, but I've been saying this for years and years and years. Get nurses, get legal nurse consultants involved in your cases. The nurse will help you take it to a different level. It happens every time. We love working with OnPoint, been working with them for many years. In fact, Patrick, I need to actually talk to you today because I am in need of 2 very important types of experts. So I need to chat with you about that today. But what they do at OnPoint is not only provide this extraordinary talent and skill in terms of nursing, but they do things that I've seen other people, I'm not being critical of them, just don't do. I'll give you an example of something. I called them one afternoon, actually it was on a mass tort case, and we needed a super specialist PhD nurse to consult with us on a Zoom call. Are you ready for this? At 11 o'clock that night. And I said, please pull out all the stops, find that person. And within a couple of hours, they were back to me and they said, we got your person, send the link. And it was amazing how important that call was to this particular mass tort campaign. That responsiveness, the ability to get the right person, so to speak, on the job immediately to help the people you're working with is extraordinary. And obviously, you know, I love those pain and suffering reports, and I've found them to be especially effective at mediations and to provide to the mediator and often even to opposing counsel. So we love working with OnPoint, and thank you for everything that you do every day with us at Connectionology. Thank you, Patrick.
Thank you, John. I appreciate it.
Yeah. And we will definitely see you soon, Patrick, because we've got another webinar coming up on Thursday. And you guys have to go check this out. John, you know, our wonderful speaker again, he's going to be speaking, Bruce, on Thursday. And you guys do not want to miss that. But
Yes.
Patrick will be back with us as well. And don't forget to, no, you already beat me to it. You put your information in the chat box. So thank you for doing that, Patrick.
You're welcome.
We'll see you soon. All right, Lloyd and Cody, John, back to you guys.
Great. Thank you. Thank you, Ginger. So I'm not going to talk anymore about the tech sort of background or the technology before trial, because I want to leave enough time to talk about this case where it all kind of came together for us. And this is a case, and I'll share my screen here again, of Yarbrough versus Cardiovascular Group and some other defendants as well. And the gentleman at issue is Ron Yarbrough. This was a case we just tried this past July, and this is his wife, Glenda, beside him and his grandbaby. Ron was 64 years old, been married for over 45 years, two children, Jessica and Jim and the three grandchildren, son-in-law. And Ron was pretty typical for Southern men. He had some high blood pressure. He had some diabetes, not a great diet, but everything was pretty stable. And he was under the care of a cardiologist for many years. This gentleman, Dr. Friedland. Ron didn't have any major issues with his heart, but he did have high cholesterol, was on medications called statins to keep it under control, was taking his medicine like he was supposed to. As a retired postal worker, loved to fish, loved to hunt. We would say a good old boy here in Georgia, very well loved by, of course, his family and friends and neighbors, and just a really good guy. Ron went to see Dr. Friedland for regular appointment on October 15th, and everything was good. His reports were good. His examination looked good, no issues. But Dr. Friedland decided, he's like, we hadn't seen you in a while. I'm going to send you to get what's called a coronary calcium score. And this is a test where they send you off to an imaging suite. They put you on a table like this. They put you into a big donut and they take a picture of your heart. And they're looking at the coronary arteries or the heart arteries to see if they have any buildup of plaque. And they give you they send a report to your cardiologist, and this is what happened with Ron. Ron went to get this test. The test come back, and this is one of those tests that you really do not want a high score. It is not like the SAT or the ACT. You really want a score of 0. But unfortunately, Ron's score came back very high. And particularly, he had a high score in a specific one of his heart arteries called the LAD, which just means left anterior or front descending. So it's this left artery that goes down across the front of the heart muscle. And he had a high score, and a high score is bad because it means you've got a lot of junk in your heart artery. They look at the other vessels. His score wasn't great, the other vessels either, and his total score was 672. It's got a lot of stuff in his heart arteries. The radiologist describes their impression and said a calcium score greater than 401 corresponds with extensive atherosclerotic plaque, and there is a high likelihood of at least one significant coronary narrowing. Now, what that means is that if you block off one of the coronary arteries, you will have a heart attack, and the heart muscle will die, and you might as well. Now, here's another way to sort of visualize it. You see to the left, a score of 0 means your arteries are clear, no buildup. But you get over to the far right in the 400 range, and that means extensive coronary artery plaque. A lot of junk in there that needs to be appreciated and addressed. So the test is done. The test is sent to Dr. Friedland, and then they bring, and then the test is communicated to the cardiovascular group 4 days later. And then there's internal messages between the doctor and the nurse. And these are the internal sort of text messages between Dr. Friedland and his nurse. And it's a little bit wonky to read, but the way it reads is that Dr. Friedland is sending this message to his nurse, Susie Clark. And he says to her, call the patient with the test results. And then Dr. Friedland provides information about what he wants to be communicated. The calcium score is elevated. He had non-obstructive disease by cath a number of years ago, continuous aspirin and his cholesterol medicine. And then critically, he says, if there are no cardiac symptoms, there's no need to do a stress test. So this is Dr. Friedland telling the nurse, call the patient, give him this information. Well, there's no phone call. No one from the group calls. The nurse doesn't do what she's told. And instead, she sends a letter, snail mail, critical medical information being sent in today's U.S. Post Office. Think about that. But that's what she does. She sends this letter, And the evidence was that this was a form letter. This is a template that they use to communicate patient health test results. And she sends this letter, and it says, your recent coronary score was reviewed. It showed no significant calcification in the arteries leading to the heart. Well, the testimony at trial from Dr. Friedland and others was that this letter was 100% accurate, except for the word no. And I had some fun with that in closing argument. It's like, how many other sentences or test results have a very different meaning if you take away one word or you change a yes to a no? Your pregnancy results were positive, were not positive. You have cancer. You don't have cancer. I mean, these words are important. That was not a great argument by the defense, but they made that argument, and they acknowledged that this was a typo and it was a mistake. It goes on to say, if you are not having any symptoms or problems, there's no need to perform a nuclear stress test this year. So it gives the wrong information. Now, it did include the test results attached to this cover letter. And the defense made the argument, Ron should have reviewed the report that was attached to the cover letter. Our response to that was, this is a relationship Ron has had with his cardiologist for 30 years. He trusts him. He trusts a letter that he gets saying everything's good to go. So 2 weeks later, after Ron has gotten this very high calcium score, his wife calls back to the practice. And this is reflected in these internal messages. And this is on November 12th. And Glenda calls back, and they said it was patient's sister. That was a mistake on their part, because his sister has nothing to do with anything with his health. And it was undisputed that it was Glenda. But Glenda called back and stated that Ron was having shortness of breath and diarrhea from the new medication. Goes on to say that the patient says since starting the rosuvastatin, which is the cholesterol medicine, he's had tightness in his chest and shortness of breath walking to the mailbox. So now Ron is reporting through his wife cardiac symptoms that he thinks are caused by his cholesterol medicine. And then Glenda says, or the nurse says, please call him. This is to Dr. Friedland. Please call your patient. Here's his cell number. Later that day, at the end of the day, Dr. Friedland, at around 6:40 in the evening, responds and says, stop and go back to the simvastatin. Thanks, and he puts his initials. And what he had said he was communicating was stop the new cholesterol medicine and go back to the old cholesterol medicine. Well, the problem with that is cholesterol medicine does not cause the symptoms that Ron was reporting through his wife. It does not cause things like shortness of breath or chest pain. So in the face of a patient who's got this very high score, particularly in the LAD, which is known in medicine and colloquially as the widowmaker artery, because it's so important, there's no discussion with Ron about these new symptoms and what they may mean. There's no instruction to Ron to come back to our office so we can evaluate you, or at least go to the ER. And there's no stress test. And then there's no discussion about the significance of the calcium score in the first place. There's just this letter giving the wrong information. So that's kind of the chapter about Dr. Friedland. And Ron goes back to his old cholesterol medicine. He thinks his heart's okay. He thinks he's trucking along. He's in good shape. He's leading his life until about 6 months later. Ron goes back to see his cardiologist, a regular follow-up appointment. This is Dr. Friedland's notes. And nowhere in the notes is there any mention whatsoever of the CT calcium score. There's mention of a bunch of other stuff, prior tests over the years, results of examination, medications that he's on. No mention anywhere of a CT calcium. 3 days after this routine visit, and the visit's good. Um, Checkup's good. Ron's heart sounds okay. There's no testing done, but just the basic listen to your heart, breathe, that kind of thing. Everything looks fine. Ron thinks he's in good shape. 3 days later, Ron has a particularly nasty stomach ache, feels pain in his abdomen. He goes to the emergency room. Emergency room gives him some medicine. They say everything seems to be okay. Go to a GI doctor and get checked out. And that's what Ron does. And Ron goes to GI doctor and gets a colonoscopy. Colonoscopy comes back and shows a non-obstructing, meaning it's not blocking the colon, but there's a large mass found inside the colon. And they biopsy it during the colonoscopy. It does not appear to be cancer, but it's not definitive. It could be cancer. You just don't really know until you go in and take the whole thing out so you can have it properly examined on pathology. But so the GI doctor sends Ron or notes that he's going to refer him to a colorectal surgeon to evaluate what to do. So GI doctor connected Ron with a surgeon named Dr. Venkatesh. This is Dr. Venkatesh, who's also a defendant in the case. Dr. Venkatesh meets with Ron, and he learns that Ron has been under the care of a cardiologist for many years. Dr. Venkatesh learns that Ron is on a number of medications related to heart issues. He documents that Ron has a number of risk factors for heart problems, such as diabetes, high cholesterol. Ron's age, 64 years old, also is a risk factor. And Dr. Venkatesh recommends a surgery, a laparoscopic resection, colon resection, basically open Ron up, cut out the intestine that has this big mass, and stitch them back together. The problem is that is a very significant surgery, puts a lot of stress on the heart, and it's very important to get cardiac clearance before doing the surgery to make sure the patient's safe. Well, Dr. Venkatesh does not do any of that. Even though he knows Ron is under the care of a cardiologist, he does not send Ron for clearance. Instead, he asks Ron about his heart. He said, "How's your heart doing?" Ron says, "My heart's good. I've just been to my cardiologist. He says everything's good." Of course, Ron doesn't know about his high calcium score and his widowmaker artery that's almost clogged up. And Ron says that his cardiologist says, his heart's fine. So Dr. Venkatesh chooses not to delay this elective surgery, meaning this is not an urgent surgery that's needed right now. It can wait. But he decides not to delay, instead proceeds with the surgery without telling Dr. Friedland and without getting any cardiac clearance. So leading up to surgery, Dr. Venkatesh knows that Ron is under the care of a cardiologist, that Ron has multiple risk factors for heart problems, diabetes, etc. But still, Dr. Venkatesh does not even pick up the phone to call Dr. Friedland. So going into surgery, Dr. Friedland is completely in the dark. And Dr. Friedland will tell us, and did tell us, that he had no idea that his patient of 20 plus years is about to have major abdominal surgery. And Dr. Friedland says that if he had been notified, he would have taken very specific action. Let me stop sharing and make sure I've got my audio on. Yeah, there we go. This is what he said. And if you had been contacted specifically by Gwinnett about informing you that Mr. Yarborough has been recommended for resection surgery, then you would have insisted that he get cardiac clearance, even if they didn't request it specifically or not. If you learned that he was facing resection surgery, you would have contacted Mr. Yarborough and said, "Hey, come in, we need to clear you, make sure you're safe for surgery."
Objection to the form.
Is that fair?
Same
Yes.
objection here.
Yes.
And of course, the answer is yes. I've I've sort of made the point before. I think it's valid. The more objections you tend to get on a question, that could be a good indicator that you've asked a good question, and you should spend some time on that area. Um, this also kind of underscores why it's so important to videotape these depositions, because just their reaction and their objections, I think, signal to the jury that this is an important area and they don't want the jury to know about it. But yeah, Dr. Friedland, to his credit, agreed, yeah, if I had known about the surgery, I would have had him come in for clearance. But of course, then you have to tie in the causation. Now in Georgia, I always try to use video clips if I can in an opening statement. Video clips of the defendants, portions of their testimony. Sometimes judges let you do it, sometimes they don't. But what I do, just in case the judge says no, you can't play clips, is I'll have a board with the exact quote static, like it's displayed here, so that you can at least preview that to the jury going into during your opening statement. So I have that repeated here. But would it have made a difference? So, okay, you would have had clearance. You would have required clearance. So what if Ron had come back for clearance? Would that have changed the outcome in this case? And we asked Dr. Friedland that if Mr. Yarborough had been sent to you, you would have had him do a stress test as part of that clearance. And he agreed. I would have had him do a stress test. You get up on the treadmill, run until his heart rate is up, take a picture of it, and see if the blood flow is affected. And the stress test would have demonstrated impeded blood flow. And he said, yes, and that would have led to a catheterization, which is the definitive diagnostic tool to really look at the blood vessels and see what's blocked up. And he agreed that would have more likely than not happened. And and the cath would have revealed the blockages. He said it would have. And if you had discovered these blockages before surgery, would that have led to a different outcome? And Dr. Friedland, to his credit, was honest about this point. He said, yeah, he would have either had open heart surgery, coronary bypass, or possibly medical therapy, but we would have done something. We would have done things to protect Ron and given him the best opportunity for a good outcome. So if Ron had received proper treatment before the surgery, would he have survived? That was the big, $1 million question. Would he have survived with proper treatment? And this is what Dr. Friedland said.
If he had been managed by medication, do you think more likely than not he still would have died as a result of the resection surgery?
No.
Do you think he would have survived the resection surgery?
Yes.
Now, I was pleasantly surprised at his response. I was expecting, a discussion about how, medicine is an art, not a science, and you can never tell, and it's just impossible to say. But again, to Dr. Friedland's credit, he said, yeah, if we had managed him properly, if we'd had that opportunity, then he would have survived. Now, of course, what he was doing, I believe, was putting some shade on the colorectal surgeon for not giving him an opportunity for clearance. But he was forthcoming on that point, which was helpful. So with no cardiac clearance, Dr. Venkatesh performs the surgery, this colectomy, and then predictably 2 days later, Ron starts, they detect that Ron is putting off these enzymes, high levels of troponin. His troponin level's gone up. And I explained to the jury that troponin is just a chemical that when the heart muscle dies and it starts decaying, it puts off chemicals in the bloodstream that can be measured. And that's all troponin is. It's just a sign of dead heart muscle. And then they noted that he had this thing called a non-ST elevated myocardial infarction. It's just a big word for heart attack. Ron has now had a heart attack because his heart could not survive the stress and the trauma of this major surgery with all these blocked vessels. So now he's had this he survives the heart attack. He's of course still at the hospital, but now he's had this heart attack. And finally they do the cardiac cath to really see what's going on. And this is when they put a little tube up towards the heart vessels. They squirt some radioactive dye to get them to light up. And then they take an x-ray and it lights up. and this is what it looks like. And cardiologists are, of course, trained to interpret what that means. This is the record as a sort of a diagram showing the left anterior descending, which is the one on the left of your screen, and then it's kind of colored in where all the blockages were. And this is, of course, this is the most concerning artery, again, the widowmaker, and they call it that for a reason. But as I was heading into trial, or getting ready for trial, I was struggling with how to show this in a way that'll be accessible to a jury. And I had met Cody over the years at seminars, and always admired the quality of their work building demonstratives. And I talked to him. I was like, "Do you have some ideas on how we can sort of show this in a way that is accessible?" Because talking about coronary artery disease, that just seems very intimidating to people, without that kind of medical background.
It was intimidating to me, Lloyd.
Well, you've got some great animators. I was kind of getting hazed by one of the attendees in this webinar who's joking that, hey, Bell's over there promoting products that are, undercutting Cody. And I was like, well, not exactly. The product I'm showing shows you the normal anatomy, which is very useful. But in medical malpractice, you come into unusual situations where you need customization. And that's where you came in and your team came in, Cody. And we had a lot of discussions about how to show this. And to me, this is pretty impressive and dramatic. But I showed this to people around my office, and they said it just looked like a bowl of spaghetti and didn't make any sense at all. So I'm like, well, this isn't going to do it. So I did show an opening that the CT score, which showed the CT calcium, which showed this very high area of stenosis or blockage in this part of the artery, corresponded exactly to what was later found. And so then that gives you a very powerful rhetorical device, which is to repeat, if only they had taken him seriously, if only they had said, come back to the office when he was reporting shortness of breath, if only they had had him come back when he was reporting chest pains, and just put him up on a treadmill and take a look, they would have seen this 6 months earlier before it was too late. And Cody, I'd like just to give you the floor for a moment. This is the first part of the animation, but can you sort of give a description of how we worked together and kind of came to the solution that I'm going to go through here in just a minute?
Yeah. So on the right, you can see the CT, and the issue was, to any layperson who doesn't look at this, kind of like you said, Lloyd, is it looks like a bowl of spaghetti or just a black and white image. That if you show a normal person that, they wouldn't say, "Oh yeah, those are heart arteries." Yeah, exactly. And so we wanted to show the heart, and we had a couple different versions, and we settled on this version because we rotated the heart. If you see the heart, it's kind of the ribs and stuff. It's actually rotated. We tried to orient it the same as the CT, so that the viewer could actually more easily make an apples to apples comparison there. And so showing just, okay, there's the heart and there's the medical imaging. And what the medical imaging does side by side is it gives credibility also to the graphic, that it's not just a cartoon. And so as you progress forward, you can actually, it takes you through all of the, I'm just going to speak in lay terms, clogs, the clogs of the arteries, right?
Well, and this was the most powerful demonstrative I had in the trial. I call this my anchor demonstrative, but the way I presented this in opening was in digestible chunks. So this is, I oriented, just like Cody did, I oriented the jury. Obviously this is a illustration of the heart, but on the right is Ron's CT angiogram. This is real. And the place that has the little number 1 and the 95%, that's the blockage. and we can correlate that to the call out, number one, 95%. You can just see how much junk is clogging up this pipe. And it's real important in these medical cases to use the simplest language, the most direct language. Don't want to say coronary arteries. They're pipes. And the pipes and I've explained this earlier, but they're pipes that supply the heart with the food it needs to survive, which is oxygen and blood. But the pipe is blocked up, 95%, almost completely blocked off. And then down here on the left, you can see the name of the vessel, of the pipe, the left anterior descending, because you do have to get the jury comfortable with the language. So as experts talk, yeah, but when they think LAD, just think of the big pipe, the Widowmaker, which was a very convenient name. And then we see the second blood vessel, the ramus, also blocked 90%. But wait, there's more. Then we see number 3, the third vessel, which is a branch of the LAD, blocked 90%. And we see and the color coding I thought was brilliant, Cody. That it really helped it stand out. And then number 4, another branch of the LAD, a fifth vessel, part of the circumflex, which is just another vessel a little bit further away, or distal they call it, but that just means a little bit further away from the top of the heart, 50%, and then another 90% blockage further down, the circumflex. And all of these blockages were there 6 months earlier, more likely than not. Anything's possible, but more likely than not. But these are all represent little ticking time bombs in Ron's chest. And every day that went by, every minute that went by, these ticking time bombs were there, just completely unknown, because Dr. Friedland hadn't worked him up to discover this. So once we sort of furled the animation just the way I did in opening, I had this board printed and mounted on a big board, not quite a billboard, but it was big, and because it has a lot of information. And I called it an anchor board. I just kept referring back to it. I just with experts, doctors, defendants, and then I stopped talking about the individual components, and then this became Ron. This was what was going on in Ron's chest. Doctor, but you didn't know it, did you? And then it just becomes an example of horrible blockages that nobody knows about because they didn't do what they should have done. So very, very powerful illustration. As a result of the heart attack, Ron's in the hospital. He lasts for about 36 days. He has ups and downs. They think he's improving. They do a surgery. The surgery developed complications. His heart capacity was just failing. He didn't have his ejection fraction had gone down, meaning the heart wasn't strong enough to pump the blood out that it needed. And after about 36 days in the hospital, Ron passed away, and the family had to make the heartbreaking decision to withdraw life support because Ron was gone. So that was what happened. Now, this is where the heat came in on the case. More heat came in. 2 weeks later, Glenda's going through Ron's effects at the household, and she's looking at paperwork and whatnot. And she comes across the letter from the nurse saying, no calcification. But Glenda, her husband just died of a heart attack or heart-related issues. So she looked further and she sees the report and she says, hey, this report is inconsistent. So she calls a nursing friend of hers, and the nurse and then sends her the report. And the nursing friend is like, yeah, this is messed up. This is inconsistent. You need to get all the medical records and have it looked at. Somebody made a mistake here. And that's what Glenda did. Glenda sent off a request for all of her medical records, certified copy, all scans, all outside records. And cardiovascular group responded, and they swore that they had produced a complete file and that no documents have been omitted. This was their representation. Well, I said this to the jury. I go, what do you suspect was omitted from the complete medical chart, the so-called complete medical chart? Well, of course, they didn't produce the letter that they had sent Ron saying with the typo that there was no calcification. They also did not send the CT calcium results at all. And of course, the medical record that they did have didn't mention the CT calcium score, just completely gone. Now they did mention, an older test result that was reassuring and normal. So it's like they knew how to send test results, but they didn't send the one that would cause the finger of blame possibly to be pointed at them. So I argued in closing that what they did essentially was they went in and they cleansed the record. They Cloroxed or bleached the record to take out the things what they knew they had goofed up on. They knew they had mismanaged this patient, and they wanted to keep the grieving widow in the dark, and they didn't want her to know about it. I can only imagine the conversations they had to come to that decision, but that's what happened. So I argued in closing, I put the slide together. It's kind of fun, but I put the slide together that what we have is really a web of deceit. We've got the cardiovascular group withholding the CT calcium report from Glenda while they represented that they were producing everything to her and withholding nothing. They withheld the letter, the no calcification letter. They erased any reference to the CT calcium score from Ron's records, and then they provided this reassuring test from 2017, which was before, of course, the CT calcium. But it's like, oh, look, he was fine. Here's this old stress test that was normal. It's like, well, everything designed to mislead her and to reassure her that they did not do anything wrong. And of course, they didn't realize that she had the letter herself the no calcification letter they didn't realize she had that in her possession. One thing we've started doing, so that's sort of how we presented the case. And one of the things I've started doing in these trials is to file a motion to bring in my own videographers and to videotape the trial. CBN has been doing this, been videotaping my trials for a long time. And sometimes I've screen captured their video when they're live streaming, so I would have access to it. But they don't work for me, so I don't have control of their video, and the quality. It's gotten a lot better, but back in the day, it was not the highest quality because it was hard to live stream high quality, high definition video. So I started bringing my own cameras in, and I'm glad I'm doing it now. And the reason I'm doing it is because a number of reasons. One is I think it's proper to use video in the actual trial. For example, when we videotape the opening statements and the defense stands up and makes a bunch of misrepresentations and promises they can't keep, I think it's useful to remind the jury of what they said in opening. So let me show you a clip of what was promised to you in opening. I've had one judge allow that, and you would think I was throwing, holy water on a vampire. I mean, they freaked out. It's like, it is completely improper to show the jury what I said in opening statement. I mean, it was, and they said that in front of the jury, which was, I don't think very useful to them. But that's how powerful it is. And we are always the truth tellers. We're the ones who are trying to reveal the truth. We're the ones who are trying to clarify and simplify and reveal the truth to the jury. And the defense, at least in my experience, is often trying to, use confusion, the campaign of confusion. My girlfriend Julie Green likes that expression a lot. It's a powerful one because it's true. There's this campaign of confusion, and we try to clear that up. And videotape's very helpful. It's also helpful because you can use it later and review it at night during the trial. It's like watching game tape if you're a football coach, and you can review the testimony. You can pay closer attention to the witness's mannerisms that you might not be seeing because you're doing something else. You can share the video with other people on your team and get feedback of what seems to be landing, what points landed most with you. There's all kinds of benefits to it. And this is a clip from the trial, I just want to give an example of what I'm talking about. What was so at this point in trial, this is Dr. Friedland. I've already called Dr. Friedland in my case in chief to testify under cross. Dr. Friedland testified that yes, the standard of care required him to bring Ron back to the practice for further evaluation when Glenda called reporting these cardiac symptoms. He acknowledged that under cross-examination in the first part of trial. Well, for some reason, he had a change of heart over the next couple of days before he was called back to the stand by his attorney. And now I'm having an opportunity to recross him. And this is an example of that in the benefit of the video.
So the defense chose not to put the November event up here, but it's actually on my timeline on November 12th. And in that 2 weeks after getting that coronary calcium score, Glenda's calling back and reporting that her husband is experiencing shortness of breath and tightness in the chest, right?
Yes,
And
diarrhea.
And diarrhea. And you told us just a few days ago that the standard of care required a response to that information, right?
Not necessarily.
You told us 2 days ago that the standard, I think it's 2 days ago, that the standard of care required you, the physician, when learning that a patient is reporting shortness of breath less than 2 weeks after having this abnormally elevated calcium score, that the standard of care required you to tell that patient to come back in for evaluation. Remember that testimony?
He got switched on his medicines, and the implication of that message was that it was a side effect of the medicines.
So hang on to my question, please. 2 days ago, do you recall telling us that the standard of care required further evaluation of this patient in response to the report of shortness of breath? That's what you told us. Do you remember that?
I'd have to see my
It's
testimonies.
2 days ago, Doctor.
Okay.
Do you remember that?
If you say so.
Well, let's say it again. The standard of care does require further evaluation of a patient reporting shortness of breath, which is a cardiac symptom, right?
And diarrhea.
Talk about that in a minute. Shortness of breath is a cardiac symptom, right?
It could be.
It could be. And shortness of breath is not an expected side effect of a change of statin medication. You agree?
It could be.
Now it could be?
It could be.
You told us 2 days ago it
All right,
wasn't.
I apologize. No, it would not be from a statin.
Okay. So since shortness of breath would not be from a statin, you have to, as a cardiologist with all of your experience, have to assume that this is a potential cardiac issue. Fair?
Hypothetically.
And is that a true statement?
Well, my assumption was that this was a side effect of the statin. And if he had persistent symptoms, he would have called back and said, I'm still having symptoms at that point. This was a one-time episode, one message.
I want to pin this down. I understand the point you're making. We're going to get to that. But in this situation, when there's a phone call 2 weeks after this abnormally high calcium score, and the patient is reporting a number of symptoms, including shortness of breath, the standard of care requires you or somebody on your behalf advising the patient to come in for further evaluation. Is that true?
Yes.
And if the standard of care had been followed and the patient had been advised to come in, then the standard of care would have been to put the patient on a stress test in response to that symptom.
No.
You told us 2 days ago that the standard of care.
So you get the idea, but you know, he had been pretty coached up to try and backtrack on some of his statements. And of course, that was an advantage to us because it gave us another chance to kind of underscore, a little bit kind of how slippery, this defense was. I think we're probably close to out of time. I haven't gotten the poll yet from Ginger to close up. So I've got just a couple more slides that I'll point out. Every trial, if you're alert to it and your team's alert to it, there'll be what I call Easter eggs that will appear. And it's almost, you got to be alert to what those are. Just kind of gifts that that the defense will give you, or a defense witness will give you. And this was one of those Easter eggs. And another reason I'm glad that we had it captured on video. But this is Dr. Stephen Cohen. He's a colorectal surgeon, excellent doctor, and excellent witness out of Virginia. And he testifies both sides, he charges a reasonable amount, all those things. And I had done my examination, and then the defense counsel gets up to do the cross-exam. And this is just a small piece of her cross-examination.
In a lawsuit like this, some of those you'll take, some of you don't. And so back when we deposed you, you were doing about 12 a year, so now it's more than that.
Correct.
Okay. And back when you gave your deposition, you had testified a little over 100 times. Do you know how many times you've testified by now?
I do not.
More than 100.
But more likely that, yeah, since I first started in 1994, that was 30 plus years ago, and I was asked to review a case. I didn't even know what that meant back then. But yes, it's probably been over 100, probably closer to 200 actually.
Okay. And that means 200 times given your testimony. How many times have you come to trial?
So you get the idea that, pretty typical cross-examination you see by defense lawyers, attacking the expert, how many times you testified, how many states. And she went on for about 20, 25 minutes on the same kind of pathway. Well, the Easter egg and the problem for her was this testimony.
Dr. Cohen, did I understand you correctly that Ms. Miller's law firm has actually hired you themselves to review cases and participate in lawsuits?
There are many attorneys on the defense table that I recognize, yes.
So she works for a firm, McGrew, Miller, Bagley, and there's a fourth person I can't recall. And before that, with Carlotte Copeland, I believe.
Correct.
Have you been asked to work by those defense lawyers on behalf of physicians to come in and review cases on their behalf?
I have.
Has the law firm of Huff Powell that's sitting over here as well with their named partner, Mr. Huff, has Mr. Huff's law firm asked you, entrusted you to review cases honestly and accurately and report to them your honest opinion?
Yes, they have. And I think I have one ongoing case with Mr. Huff's firm, not with Mr. Huff, but one of his partners.
But this goes on for a while. But if you're going to get up and attack an expert, it's just not a great idea if your firm and your partners and your co-counsel and his partners have all used him. And the reaction from the jury was memorable. They did not hide their reaction about about that point that we were making. Just kind of to wrap up, and that's so the trial. The trial lasted about a week and a half. We argued for an apportionment of liability between the cardiology group and the colorectal group. We argued the cardiologist was probably 80% responsible, colorectal probably 20. Jury came back and said, no, let's do 70% cardiologist, 30% colorectal, which was fine. They gave us all of our medical bills, which were $1.9 million. They gave us, the jury returned a verdict of $12.5 million for the 36 days of conscious pain and suffering, and then $4.5 million for the full value of Ron's life. And the life expectancy was another 10 years based on the evidence and his comorbidities and whatnot. So, so that's how that case worked out. The technology piece, and I include the animation that Cody's team did, was a big part. We used low tech as well. I brought in some heart models, so I was able to hold up the heart. It's always helpful if you can have something physical and smallish that you can show the jury, because it gives you a chance to kind of get in close to them and show things and help create connection and relationship. And it makes it interesting. My point earlier about, that at some level we're entertainers, and it's our responsibility to make this interesting and compelling and memorable and all those things. And, the right demonstratives, the right exhibits certainly played a big role in this case. Now, last thing I'll say on that is I've got we're allowed to talk to the jurors after the trial's concluded. I know some states you're not allowed to, or maybe without a motion. And I had one of the jurors come on to my podcast. I've got a podcast called Face the Jury, very original, but Face the Jury. It's on all the streaming services. And I've got one of my jurors who came on for about an hour and a half, 2 hours, talking about the jury experience in a medical malpractice case. And I'm always trying to talk to jurors after a trial, but they're tired and they may talk to you for a few minutes and it may be useful. But the great thing about this was I asked all those questions that, frankly, I'd be too embarrassed to ask, after a trial. But questions like, what were you thinking when you first walked into the courtroom and you saw everybody sitting down? What was going through your mind? Things like that. And we explored that on the podcast. And I encourage you to listen to it if you're interested in hearing the jury eye view of a med mal trial, because she really went into a lot of detail about different aspects. So anyway, that's all I've really got today. So unless there's any questions.
Yeah, Lloyd, Ginger was going to pull in a couple more sponsors, and
Sure.
then if you feel comfortable, because I got so much feedback on your closing. If you don't feel comfortable with it, no big deal. But that closing statement that Lloyd did, whether he shares it or not, was one of the best. And I got 4 texts after our previous webinar. It was one of the best they've ever seen in the way that he showed the latter years of life being the golden years. It's just amazing. And then after the sponsors as well, we've got a couple of questions if you have time, but if you got to go, Lloyd, it's no big deal. So
no, I'd be happy to do it. And I want to be sure to acknowledge that these are not my words. There was a lawyer. I probably collected this over 10 years ago. A young lawyer had either drafted it himself or come into. I can't remember his name, but I have a big folder of good closing arguments. And I think good trial lawyers are good collectors of other people's wisdom and brilliance. And so I'm not going to take credit. I won't take credit because I didn't write it, but I think it is beautiful and I'm happy to share it. I would enjoy that.
I was really hoping that you were going to say yes. I was texting Cody. I was like, do you think he's going to do his closing argument for us?
Sure, be happy to.
we had all heard it. We had all heard about Lloyd's closing.
All right, well, stay tuned. Okay, guys, don't go anywhere because Lloyd is going to share that in just a minute. But I wanted to take a quick break because I could not pass up the opportunity to bring in Sam from Strategic. And Sam is a good friend of ours, Lloyd, right there from Atlanta, Georgia as well. But they actually do very cool work. They will go out there and they'll find these ex-employees of all these companies that you guys are up against, and they will find people you never thought existed in some of the most remote places in the country, and it will just change your entire case. I always get excited about this because I think the whole investigation thing is very fascinating, Sam. But it's great to have you with us today.
Yeah.
I will leave it up to you to share the rest.
Sweet. Thanks, Ginger. It's good to be with you all. I feel like I'm just in the room with some legends. I mean, Ginger, of course, is the best executive director there is out there. Of course, the legendary John Romano and Cody and Lloyd. So thank you guys for having me. Love you guys. Y'all are the best. So who I am is Sam Littrell. What we do is really, we have this kind of niche practice where we help find former employees of the companies that you're suing. And the idea is we want to convert those folks into insiders and whistleblowers. And so really how we do that, how we've done that the last 20 years, is we work with attorneys and we ask you typically 3 or 4 questions, usually in kind of the sphere of what's the name of the defendant that you are suing, what are the job titles of people who are going to hold relevant knowledge, when would they have worked there, and where can they now reside? And so really based off of those 4 questions, we are finding people that meet those criteria, and we can either send that information to you, giving you their names, their job titles, their tenures, their active phone numbers, or we can then vet those people and learn the stories and hopefully get you some damaging information on your defendants. So yeah, really what we do is we are trying to help you uncover the knowledge or the truth that's out there from the people that you think exist, but you're not quite sure who they are. We are your guys to help find those people that are out there that are real, that maybe you haven't gotten in discovery, but we are the guys that are going to find those people and say, hey, you know, what you're saying is true. We were overstaffed or understaffed. We were overworked. We sent that product out even though we tested it and it was trash. You know, you name it. We've heard all kinds of crazy stories of different things within different kinds of cases, but we're going to help you find the real people that really exist who have the information that really hasn't been corrupted or changed by defense counsel. So that's how you can kind of leverage us. So I'll put my stuff in the chat. Feel free to reach out anytime, and I'd love to hear more about your cases.
Sam, thank you for the things you all are doing with us at Connectionology. You've been with us since the start. You know, as I was looking at you, I was thinking about this, and I don't know why it hit me, and many of the people who are tuning in might be a little younger and maybe don't know about this, but in the 1970s and even in the early 80s, there were 3 or 4 men who were found on islands in the Pacific Ocean, deep in caves. Each one had been a Japanese soldier who stayed on duty, did not know World War II was over. And even though the decades went by, they stayed in there. You can read about it. It's extraordinary. I am positive if anybody needed to find one of those guys at the time, that's what you all do at Strategic.
Yeah.
You find people that are impossible to find. And you've done it time and time again for us and for lawyers all around the country. And I want everybody to know we work with you all because we trust you and we know if they can be found, you all will find them. So thank you again for all you do.
For sure.
Tell everybody at Strategic we said hello.
I will. Thanks, John.
Awesome. And I see that you already put your information in the chat. So thank you for doing that. And we will talk to you very soon on Thursday.
Sweet. See you then.
Okay. Thanks, Sam. All right. And Cody, I definitely want to make sure we don't end this webinar before talking about how incredible your company is as well. But I know you probably want to get to some questions. I'll let you decide which one to tackle first.
Sure.
And then I can't wait to hear Lloyd's closing statement.
Absolutely. Yeah, we could go straight to the questions because I actually have some questions that aren't even on this. Lloyd, and we got John here too. So we've got 2 of the best. And so my questions are this, because it may change the way I do demonstratives. Both of you talk about emotion and invoking emotion within the jurors, and not just any kind of emotion that goes to action, massive action, where they're going to do something about it. What emotion is it? Because I've heard different things from different trial lawyers. Well, maybe it's empathy, but I've also heard anger to really make jurors angry. That train comes right off the rails. And does it depend on if it's red or blue or things like that? Like, what goes into your decisions on which emotion you're trying to invoke?
John, do you want to go first or?
No, go ahead. Go ahead.
Yeah. So you're exactly right. And that's the question you're asking is what's the emotional response I want from the jury, and how do I get that response? And there are so-called high activation emotions, emotions that make you want to take action. And you touched on some of them. Anger is one, fear, disgust is another one. But there are also some positive high activation emotions, which I keep front of mind. Love, hope is a very powerful emotion. One of my good friends, Jesse Wilson, talks in the scope with the theme of presenting your case from victim to victor, that your client is not a victim and can't see themselves as a victim, but has to see themselves as the same person they are. They're not defined by their injury or their disability, but that they are going to keep fighting and they're going to keep, working to get to the next day, to reach the next milestone, no matter how horrible their injury. We tried a case with a young man who had locked-in syndrome. I tried it with my good friend Laura Shamp, and this young man could only move his eyes. He was in his 30s, his brain was otherwise intact, but all he could do is communicate by moving his eyes to a letterboard. And he testified in trial. And I asked him, I said, well, John, I go, what are your hopes for the future? And with his eyes, he spelled out, and this was close to my heart, but he spelled out technology. And he goes, and he spelled it out. He said tech. And he described, that he, in very broken words, he described that he hoped that tech would help him talk again through a computer. And he's getting, this is just sort of the end of the story, he's getting he's been approved with the Neuralink, Elon Musk company, but Neuralink, and he's been approved to have a chip implanted in his brain so that he can hopefully communicate through a computer, but he's a candidate for that. So his hope is actually being fulfilled. But those are some of the kind of emotions. The anger is, if you can find it, if you can find the lie and try the lie, as our friend Don Keenan likes to say, try the lie, those are going to elicit those emotions. But just anger and hostility without a connection to hope and love is sort of a cliff. I mean, it just leads you nowhere. You want to connect it to something positive so the jury has somebody to fight for instead of just fight against. So that's kind of my frame of mind.
Well, I'm in total agreement with Lloyd, and that is a great question, Cody. And the first thing that hit my mind was, and it comes to mind because of watching the video clip of Lloyd cross-examining that physician while he is holding one of his boards in his hand, and he has the board facing the jury, okay? What he is doing is putting the cloak of deception over the defense. And to me, just holding a board like that can assist you as an advocate. So anything that I'm going to use as a demonstrative aid, I want it to help me cloak deception on the defense side and build trust on the plaintiff side. So if a doctor says this particular area of the spine is just above this area, it's one thing for her to say it, but then you bring out the spine model and she stands in front of the jury and says, here it is, what I just told you. This is here, this is here. And then we go to an animation that you create. So they go, she said it, she showed it. Now we see the animation, and now we see the surgery, and they trust in your doctor and cloak deception with the other. So to me, that's the key.
Got it. Thanks, guys. Yeah, because it's just giving me ideas like with and the attorneys can do this too. I've seen great attorneys kind of their closing slide. There's this psychological with not just yellow, but there's also this warm, like it's almost like a sunshine yellow. And that's the background. And then they have all of the hope, the victor, and they close with that. And that is a demonstrative that I don't have to do, you can do. And you can label out, the points of hope. And so anyway, these are just ideas. As I talk with you guys, I always learn about 20 things. So it's really fun. But let's get into the other attorney's question here. Steve Gardner asks, when did you first show the demonstrative? Was it in opening, deposition, closing, and why?
I showed an opening as I was explaining the story. And so I showed the slides, the builds on the slides as I was going through opening. And then I had the board printed out and I used that board with my expert. I don't like to use demonstratives with the defendant or the defense expert for the first time because they will find something wrong with it to try and pretend that it's not reliable. So I'll typically hold my demonstratives and use them in the evidence part with my client or my defense expert or my expert, which is what I did in this case.
Great. I guess this one's for me. Cody, if a trial lawyer wants to get your initial thoughts, and this is from Doug. Doug from Florida. Doug Beam. If a trial lawyer wants to get your initial thoughts on visuals for a case, what is the cost and how much lead time do you need to get the visuals prepared and to show the medical expert witnesses to have them customize them before testifying? So good question. Obviously, talk to us anytime at no cost. And I might even quote Lloyd or John and give you some tips about what I've learned, hanging around these guys. So talk to me and my team anytime. But the lead time is important because getting this consistent with your expert's testimony is huge. And when your expert, when your doctor, your engineer, whatever, is actually in the creation process, it also becomes the expert witness's work product. You work together with the engineer, you work together with the medical, graphic designers and illustrators. And so that and getting it in perfect harmony with their testimony is really the biggest thing about lead time, especially med mal cases, because they're usually complex. Like it's usually like a neuroradiologist missed it, like a trained. And so when we're looking at it, we're like, oof. All right, we have to read your experts' reports, Lloyd and John, to to understand exactly what was missed, because a trained neuroradiologist missed it, for example.
Right.
Yeah.
Let me jump in. Just one thing. Please get your demonstrative aids to the extent that you can early.
Yeah.
You want to be using them in depositions. And if you have, let's say, an auto case, I know many of you watching today handle premises and auto cases. The defense will more often than not depose your treater. When the defense lawyer says no further questions, you don't want to say, I don't have any questions. You now want to conduct a direct examination. There might be a time to not do that, but for the most part, you want to do that. Use your demonstrative aids. Some judges, and I had this happen about 6 or 7 years ago, the judge said as to one of our demonstrative aids, was it ever used in a deposition? We said, no, Your Honor, but he goes, you're not going to use that one. I said, okay. He wouldn't let us use it. So it's not like I can cry over it. I can't use it. Lesson learned. I'm never going to let something like that happen again. You want to use your demonstrative aids. And if you're sitting back going, well, I want to do this case on the cheap, I'm going to wait until docket call on Friday. And when the judge says you're up Monday, then I'm going to call and say to Cody, I need a rush job. Don't do that. I'm done.
And like Lloyd and John and all the greats, they're always calling me months ahead of time, and they're really thinking about the presentation and the story of the case well in advance. So here's another one. What is the podcast? It's Face the Jury, and I've also have a link here, podcast.belllawfirm.com.
Yeah, and it's on Apple and Spotify and all those, I think some other platforms too, but
And I think that's so awesome that you're interviewing the jurors. That's and the fact that you're also videotaping the trial itself, you yourself is videotaping, and so you can pick up on the nuances of the experts and stuff. I've not heard of people doing that. I've heard of CVN and all that, but to do it yourself is so cool.
One of the things we're going to use it for in our podcast, I've got a big flat screen TV, and we're going to show parts of testimony or cross-examination, other lawyers, whatever, doing things, and then have reaction videos. So I'm excited to use the video from the trials as part of the podcast, and some teaching and some other points. So yeah, it's a lot of fun.
Great. I think we've got, oh, it looks like some others are answered here. So, well, Lloyd, do you want to take it away? And
Yeah, John doesn't know it yet, but I'm gonna give the hard sell to get him as a guest on my podcast. And
I'm in.
I'm looking forward to that. Yeah. So one other point too before I do the part of the closing. So I was telling John this before we got on, that when in the early days when I was doing really cases involving complex regional pain syndrome, which are some of the hardest cases in the world.
Yes.
John has always had a real interest and speaks a lot at AAJ and other events on how to discuss pain. And what stood out was how you would subscribe to magazines like Pain Magazine to understand it from a physiological point of view, and to talk about it beyond, it hurts. I mean, well, what is pain? What are the pain pathways? What are the ways to mediate pain and to reduce it, and spinal cord stimulators and all this kind of thing. And that always sort of stuck with me, that kind of creativity and the idea of kind of going into the sandbox of the defense or the doctors to learn and to be more effective representing our clients. And so I had John Romano's teaching in my mind when I was having a discussion with an ER doctor friend of mine. And he practices at a rural hospital in Georgia. Really good guy, very good ER doctor. And we started talking. I said, well, I mentioned his name. We'll call him Bob. I said, well, Bob, I said, this may be crazy, but is there any chance that I could come shadow you at the hospital for a shift? And he said he thought he could. He said, I think so. Let me check with the administration. And I wasn't optimistic. I was, I was actually thought there was no way in the world this would ever happen. But I said to him, I said, well, what I'll agree to do is to keep an eye out for any system failures, any potential sources of liability, and I'll share with you and the administration anything I see that could be a problem and expose you to liability. And he went and talked to the powers that be, and lo and behold, they agreed to let me come shadow them. And I went online. I bought a pair of scrubs. I watched the show called The Pit to make sure I was wearing everything correctly. I made sure, I was trying to look the part. I did check all the ethics rules, of course. And the only real requirement was that everything be disclosed to the patient and get their consent. So I had a chance to spend a 12-hour shift. I think we saw 75 patients. We saw 75 patients. And it was absolutely fascinating to sort of go behind the scenes and see how medicine's practiced in real time when people's guards are down and how people talk to each other. So I don't know if anybody who does MedMal would have an opportunity to do that, but if you do, I would encourage you to take advantage of it. All right. So this is how I ended the closing argument in this last trial. And again, this was a case where a gentleman had died in his later years and didn't have that many years left to live. So this is what I said. We've all grown up knowing that the last of something is the most precious. As young kids, we fought over the last piece of cake or the last brownie, and we enjoyed the last bite knowing that there would not be another. We learned as teenagers at the theme parks, the last 30 minutes is when we try to squeeze in as much enjoyment as we can because we know it is soon ending. or maybe at the school dance when they're playing the last song. For many, it's the last days of fall when it's almost too cold to be outside, and those last days seem more precious than the earlier days that were taken for granted. For some, it's the last days that our children live with us, knowing that they will soon be leaving to live on their own, leaving us with a life that is forever different. We know that last moments are precious. We've learned this. It's not a secret. But the most precious last moments are those last years of our lives, aren't they? After we've lived, we've loved, we fought the good fight, those last years when all we want is just to get off the treadmill of life, to step out and catch our breath, because we know we don't have that many breaths left. Those precious last years where the most beautiful thing is to sit on a porch and watch clouds slowly drift across the sky that we may not get to see 10 years from now. After all the life we've lived, are we not allowed to have a few precious last moments in the one life we've been given, the only life we have? The defense would try to defy common sense by suggesting that the last is worthless, that the last is cheap, that the last doesn't matter. But this defies everything that being human has ever taught us. That's why we say, you've saved the best for last. But they took the best away. They took away those sweet last years and turned them into painful ones. There is no next dance, and the theme park won't open tomorrow. These are his last years, and the defense declares that they don't matter. And maybe they don't. Maybe that's why we have a jury to tell us what matters and what doesn't, what's valuable and what's not, what can be tossed aside and what must be cherished. You are the conscience of this community, and today you hold the authority to declare if this man's last years are precious or worthless, not because you know him, but because you know life, the human experience. And no, we cannot do magic here and restore what was taken, but we can choose to do what the law allows to make it as right as we can.
Wow.
That is so powerful.
Is that nice?
You cannot help but tear up, even not knowing everything about the case and knowing the people. That is just extraordinary. And I hope everybody knows that you don't just off the cuff say something like that. You live with a case and clients, and I know how you work, Lloyd, and you thought, I'm sure, months, maybe even years, what am I going to say when I get up there on summation or to cross-examine? And it's just your extraordinary preparation, that perseverance, and the way you care about your clients. That's what I felt when you were saying that. What I felt is, this is a lawyer who has put his arms around his clients. That is just extraordinary. Wow.
Thank you. Yeah. Thank you so
Wow.
much. Yeah. A lot in there. And I like the way it ends and places the moral weight on the defense of them taking something precious, and I think that we're allowed to say conscience of the community and invoke these kind of themes. I know some states can't, so obviously check your state, but yeah, it seemed to land, and it seemed to fit the case. This wouldn't fit every case, but
Yep.
So
Yeah. All right. Any final comments? Final thoughts? I don't know how we can top that.
Yeah.
no, I just want to thank you, John, for letting me come on.
No.
This this is as good as it gets, talking about these cases and what we do, and we don't talk enough about this because it doesn't seem particularly dignified, but it's just so fun. I mean, what we do is just fun and exciting and meaningful, and I feel very fortunate to be in a place where I can represent wonderful people and do this kind of work. So.
Oh, it's extraordinary. Well, Ginger, Are you there?
I'm here. I'm just glad that you guys gave me a minute to compose myself because I was so mm, that was an amazing
I
closing.
know it was. It
Yeah.
really was.
I want a
Um,
bunch of gingers on every jury that I have.
oh, I've been like wanting to be on a jury, but nobody ever picks me. It's not fair. Like every time I get called in to go down to, the Orlando courthouse, I'm like begging to be picked, and I think it's because of what I do. But I would be a great, oh, trust me,
Yeah,
I
you
I
would
would
be a great
be a
juror.
wonderful juror, that's for sure. Um, I did not want to end this webinar without bringing in our friend Ted Mullis from HMR because he is here to announce the winner of today's coffee giveaway. And I am so excited. I already got a sneak peek, so I know who it is. And but Ted, please, if you can, do the honors. And thanks again so much for being here with us. I know that you've been on probably as many webinars that I have.
Been quite a few.
Hmm.
But yeah, this is a great webinar. So, thank you very much, Lloyd, and great to see you again, Cody, and always great to see you, John and Ginger. So, just love being
Ted.
on here with y'all. But I'm excited to announce our winner for today's giveaway is Jamie McCready, and she's out of Nashville, Tennessee. So, congratulations on some great coffee.
And I was so excited because I know Jamie,
Oh, you
and I
do?
can tell
Wonderful.
you, this is not rigged at all, guys. Ted literally, he will end up using, I think, AI to pick the winner. And when he told me who was winning, I was so excited because Jamie works with one of our great friends and trial lawyers out of Nashville, Jeff Roberts. And if
Uh-huh.
you have not looked into the Bard Room yet, you need to because I believe they just had their grand opening and it is just fascinating and beautiful. And it is going to be a place where all trial lawyers and other, professionals alike can go to and use this space. And he has brought in musicians and storytelling, the art, the whole creative thing. It's incredible. But this place is stunning. And he has worked 3 hard, long years on getting it ready and prepared. And I know, John, you'll be coming and speaking at the Bard Room in Nashville, probably early next year, in which we will telling everybody about it. You can all come.
March.
It's March. Ah, see, I'm
March.
excited about that.
We're
But
going to be
anyway,
there too.
very excited, Jamie. Congratulations. You'll have to share that coffee with Jeff and Max and everybody in Nashville. But Ted, thank you for being here and doing this special giveaway. You're incredible. Thank you so much for all that you do.
You're welcome. It's always my pleasure.
Thank you,
And
Ted.
Lloyd, John, and Cody, this has been an incredible webinar. I can't thank you enough for taking the time. And for everybody who's still watching, we appreciate you so much. Thanks for sharing these Connectionology webinars with all of your colleagues and friends. If you've got any ideas for webinars, just send me a message. But otherwise, we will keep going and we will continue with all of these.
Thank you so much, Ginger and John. Cody, it's great to see you all.
Great seeing you. Thanks.
All right,
Thank you,
guys.
everybody.
Stay
Okay,
tuned. I
bye-bye.
will email you soon all of the contact information to reach out to everybody. And then also, again, a link so you can watch Lloyd's special podcast. I just took a peek and he's got some great topics. So definitely check them out. And again, thank you guys so much for watching. We'll see you back here on Thursday.
Thanks, Ginger. Thank you, guys. Take care.
Guys.
Bye, everyone.